I'm Jeff Roberts, Executive Director of the Colorado Freedom of Information Coalition. And this is a short introduction to the Colorado Open Meetings Law. The voters of Colorado initiated the Open Meetings Law about 50 years ago as part of the Sunshine Act of 1972. The law begins with a powerful statement. It is declared to be a matter of statewide concern and the policy of this state that the formation of public policy is public business and may not be conducted in secret. That means public bodies like city councils, school boards, town boards, county commissions, and the Colorado General Assembly are required to conduct the public's business in the open. For a local public body, open meetings are required when there is a quorum or at least 3 members present, whichever is fewer. For a state public body, it's at least 2 members. For a meeting to be open to the public, it must pertain to public business and there must be a demonstrated link between the content of the meeting and the public body's policy-making responsibilities. So 3 members of a board getting together to talk about the Broncos or their kids is not an open meeting. But a discussion of the city budget certainly is. Open meetings must be preceded by full and timely notice to the public with specific agenda information where possible. Public bodies are permitted to close the door for an executive session to discuss only a few authorized topics, such as the proposed purchase or sale of property, specialized details of security arrangements, personnel matters, negotiation strategies, and legal matters that require legal advice from their attorney. A school board can meet confidentially to discuss individual students. Before voting to go into executive session, the public body must announce the particular matter to be discussed in as much detail as possible without compromising the purpose for which the executive session is authorized. Announcing the particular matter with specificity serves 3 interrelated purposes. It provides the public with specific information as to what their public officials will be discussing behind closed doors. It creates a more effective mechanism for policing whether public bodies have complied with their obligation to vote on discussing specific topics outside of public view. And it helps public officials avoid straying into topics that are not authorized for executive session discussions. Making decisions generally is not permitted in executive sessions. The Open Meetings Law states no adoption of any proposed policy, position, resolution, rule, regulation, or formal action, except the approval of executive session minutes, shall occur at any executive session that is not open to the public. In 2007, the Colorado Supreme Court held that even informal decision-making on important policy questions is not allowed behind closed doors. Sometimes you see members of a public body come out of an executive session and immediately vote on a matter with little or no public discussion. That can be a pretty strong indication a decision was made during the executive session. But audio recordings of executive sessions are rarely released. A lawsuit filed in district court is really the only way to make an executive session recording public unless the public body itself decides to do it. Your right to record a meeting of a public body isn't as absolute as you might think. The Open Meetings Law is silent on whether the public can record a public meeting, and there isn't much case law in Colorado on the subject. However, multiple court cases in other states have set a precedent to allow recording, and other states have recognized the public's right under the First Amendment to record video or audio public meetings that are on public property and concern a public interest. Public bodies are permitted under some of these rulings to place reasonable restrictions on when or how video recording can occur, but these time, place, and manner restrictions must be drawn up narrowly. If a restriction is placed, it must apply equally to everybody and every meeting, not just to certain individuals or certain meetings. For example, it's reasonable to request that someone record from the back or side of the room instead of the middle, so that the view of the audience members isn't blocked. The Open Meetings Law also is silent on whether the public should be given an opportunity to comment on issues during meetings of a public body. Boards, commissions, and councils typically set their own ground rules for letting the public speak during designated portions of meetings, but the rules cannot be operated in a discriminatory or viewpoint restricted way. Governments can enforce reasonable restrictions applied evenly to speakers, such as limiting the time allowed per speaker and removing a speaker who causes a disturbance. Noteworthy is a recent ruling in Massachusetts. The state Supreme Court declared unconstitutional a town's public comment policy requiring comments to be respectful and courteous, free of rude, personal, or slanderous remarks. Civility, the court held, can't be required in a public comment session of a governmental meeting. One other important thing to know when you attend meetings of public bodies: you are entitled to request copies of any materials used by the council or board during the meeting. Under the Colorado Open Records Act, those materials are no longer protected work product prepared to help elected officials make decisions once they are produced and distributed to members of the public body for their use in a public meeting. Many, but not all public bodies, post agenda materials on their websites prior to meetings so the public can read any proposals under discussion. For more information about your rights under the Colorado Open Meetings Law and the Colorado Open Records Act, visit CFOIC's free online Sunshine Laws Guide at coloradofoic.org.